Thank you all for joining the webinar on surrender of possession. So on surrender of possession, if a lessee is moving out, is lessee obligated to surrender the premises in a condition as good as lessee received it? Does it need to be in a move-in ready condition for the next lessee? This surrender of possession webinar will answer those questions and a lot more. Thank you for joining today's webinar. I'm the managing partner of Consensus Legal. At Consensus Legal, we specialize in commercial sales, leasing, and financing transactions. As you probably know, AIR CRE contracts are the best contracts on the market, in my opinion. Just a couple of disclaimers. AIR Forms Practitioner is not affiliated with or sponsored by AIR CRE. I'm not providing legal advice during these webinars. It is for education and discussion purposes. So today's 20-minute webinar is on surrender of possession. After the webinar, I'll stay on for Q&A. Okay, without further ado, let's get into the topics for today. Okay, here are the 6 topics that we're going to cover. The first is the basic surrender obligation of lessee. Next, we're going to talk about removal of alterations and utility installations. Topic 3, removal of trade fixtures. Topic 4, removal of hazardous substances. Topic 5, personal property remaining, how that's dealt with. And the 6th topic is holdover, if lessee does not vacate by the expiration date. So let's orient ourselves visually with the AIR CRE lease and what we're going to be focusing on. Today, we're going to be focusing on paragraph 7.4. And paragraph 7.4 deals with removal, surrender, restoration. These are the key provisions that we're going to address today. Topic 1, basic surrender obligation. So the basic surrender obligation is in paragraph 7.4C. This is where it appears in the AIR CRE lease. And let's zoom in on it. Under the AIR CRE lease, 7.4C, lessee shall surrender the premises by the expiration date or any earlier termination date with all of the improvements, parts, and surfaces thereof broom clean and free of debris, and in good operating order, condition, and state of repair, ordinary wear and tear accepted. And then it defines ordinary wear and tear. Ordinary wear and tear shall not include any damage or deterioration that would have been prevented by good maintenance practice. So this is the basic obligation that lessee has. And one of the things that's important to highlight is in this 4th line, and in good operating order, condition, and state of repair. Ordinary wear and tear accepted. So yes, ordinary wear and tear is allowed. That's something that the AIR lease contemplates, that there is going to be some natural wear, some natural degradation. But that does not mean that lessee can leave the premises in disrepair. If there is some system, for example, that isn't working well. Let's take in an industrial context, dock doors. If the dock doors are kind of deteriorating and not working in completely, or the bumpers are not in good shape, just because that resulted from ordinary use, ordinary wear and tear, does not allow lessee to just leave it in that state of disrepair. It has to be in operating order and a good condition and state of repair. So that's the basic obligation. Topic number 2, removal of alterations and utility installations. This is where in the AIR CRE lease, the provisions relating to removal of alterations and utility installations appears at the end of 7.4A and 7.4B. Let's zoom in on these provisions. So just to provide some background, alterations are improvements made to the premises, and utility installations are modifications that lessee may make with respect to electrical, etc. So 7.4A, unless otherwise instructed per paragraph 7.4B below, all lessee-owned alterations and utility installations shall, at the expiration or termination of this lease, become the property of lessor and be surrendered by lessee with the premises. So with respect to alterations and utility installations, the default rule is that they are to be surrendered at the time of the expiration or termination of the lease. That is the default rule. But you notice it says unless otherwise instructed per paragraph 7.4b. So in 7.4b below, it says, by delivery to lessee of written notice from lessor not earlier than 90 and not later than 30 days prior to the end of the term of this lease, lessor may require that any or all lessee-owned alterations or utility installations be removed by the expiration or termination of this lease. So lessor has an option here. Lessor can tell lessee by written notice in this 60-day window between 30 and 90 days prior to expiration or termination. Lessor can notify lessee, you must remove certain alterations or utility installations. If lessor does that in that 60-day window, lessee is required to remove those alterations and utility installations. If lessor does not provide that notice within that 60-day period, then lessee doesn't have to remove them, and they are surrendered at the expiration or termination of the lease. And then that last sentence in 7.4b is the exception for that 60-day window. It says this relates to alterations in utility installations for which lessor's consent was not obtained. And in that scenario, it says in this last sentence, lessor may require the removal at any time of all or any part of any lessee-owned alterations or utility installations made without the required consent. So that 60-day window does not apply if lessee failed to obtain lessor's written consent to the alteration or utility installation. Topic number 3, removal of trade fixtures. This one is pretty straightforward. Trade fixtures, as you know, are machinery and equipment of lessee. Lessee installs them, and they can be removed without doing material damage to the premises. That's the definition of trade fixtures in general. So with respect to trade fixtures, the provisions relating to removal are in 7.4c. They're highlighted here to orient you. And to zoom in on these provisions, 7.4c provides lessee shall repair any damage occasioned by the installation, maintenance, or removal of trade fixtures. And it clarifies in the next sentence below, trade fixtures shall remain the property of lessee and shall be removed by lessee. So there's no optionality here. With alterations and utility installations, they can be removed by lessee under certain circumstances if lessor provides notice, or they might be kept if lessor doesn't provide notice. With respect to trade fixtures, there's no optionality. It needs to be removed, and lessee has to do it, and it has to repair any damage occasioned by the removal of trade fixtures. Topic number 4, and yeah, feel free to put questions in the chat box along the way. After I finish with the presentation portion of the webinar, I'll address the questions and answers, and the questions. Thank you. So topic number 4, removal of hazardous substances. So the removal of hazardous substances is once again addressed in 7.4c. Here is the key sentence, and we'll zoom in. 7.4c, lessee shall also remove from the premises any and all hazardous substances brought onto the premises by or for lessee, or any third party. That's a key phrase. Except hazardous substances which were deposited via underground migration from areas outside of the project. And there's another key phrase here. To what extent do the hazardous substances need to be removed? To the level specified in applicable requirements or applicable law, basically. So let's break this down a little bit. Lessee is required to remove all hazardous substances brought onto the premises by or for lessee. So if lessee brings them onto the premises, lessee has to remove them. If lessee hired a third party and the third party brings it onto the premises, that's not by lessee, but it's for lessee, and lessee is obligated to remove them. But then the AIR CRE lease goes further. It says also hazardous substances brought onto the premises by any third party. Those also need to be removed by lessee. So these could be, it doesn't say affiliated third parties. This could be a completely unaffiliated third party. And the concept in the AIR CRE lease is, regardless of whether this is a party that you're affiliated with or not, whether you asked the third party to bring something onto the premises, lessee, you are the party that's required to remove it. The concept being the lessee is the party that is there on a day-to-day basis. It should be securing the premises. Lessor is not there on a day-to-day basis, and lessee is responsible for all hazardous substances, even if it's an unaffiliated third party that brings them on. And then let's focus on the last part here. The removal requirement is to the level specified by applicable law, basically. So lessee isn't required to remove every particle. If there is a spill, for example, and there are particles of a petroleum product in the soil, is lessee required to remove every particle? No, it's required to remove it to the level specified by applicable law. Topic number 5, personal property remaining. This deals with a scenario where lessee has vacated, it has surrendered, but it did not remove all of its personal property from the premises. Once again, 7.4C addresses this topic. Here is the highlighted sentence to orient yourself. And let's zoom in. 7.4C. Any personal property of lessee not removed on or before the expiration date or any earlier termination date shall be deemed to have been abandoned by lessee and may be disposed of or retained by lessor as lessor may desire. If you're a lessee and you leave personal property that has value, this sentence says you deem it to have been abandoned and lessor may dispose of it as lessor may desire. So make sure you remove your personal property if you're a lessee. And then finally, the 6th topic is holdover, a scenario where lessee has to, expiration date is June 30 and lessee needs to vacate and surrender possession by June 30 and its new premises just isn't ready and it can't move. And so it doesn't surrender possession by that date. That is a holdover. And how does the AIR CRE lease address holdover? It addresses it in the last sentence of 7.4C, which we'll zoom in on, and also paragraph 26. But let's zoom in on 7.4C for now. 7.4C, the failure by lessee to timely vacate the premises pursuant to this paragraph 7.4C without the express written consent of lessor shall constitute a holdover under the provisions of paragraph 26 below. And let's go to paragraph 26. This is where it appears in the AIR CRE lease, the key provisions, and we'll zoom in on it. Paragraph 26 entitled No Right to Holdover. Lessee has no right to retain possession of the premises or any part thereof beyond the expiration or termination of this lease. In the event that lessee does not deliver exclusive possession to lessor as specified above, then lessor's damages during any holdover period shall be computed at the amount of the rent due during the last full month before the expiration or termination of the lease, disregarding temporary abatement, but with base rent being 150% of the base rent payable during such last full month. So it's a requirement to pay 50% more base rent. This does not mean just because lessee is paying the additional base rent that it is entitled to remain in the premises. In fact, the day after the expiration date, if lessee has not surrendered in the example of June 30 expiration date, under California law in California, lessor can actually file an unlawful detainer action the next day. So that is the presentation for today. And now I will open it up for questions. Let me look in the chat box. Ty asks, for 7.4b, I had a situation recently where the lessor did not send notice to the lessee at all. They even performed a walkthrough and no note was made. Upon vacating and 120 days after vacating, the lessee sent written notice to the lessor for return of their security deposit. The lessor then wrote a letter to them stating that they will not return any of the deposit because they had to remove the improvements made by the lessee. The situation, I believe, will be going to the attorneys since the monies they held onto is significant. So I think your question, Ty, is whether this is permissible, whether the lessor in that situation can charge lessee by retaining the security deposit. It charged lessee to remove these alterations. And It appears that they didn't give that notice, that 60-day window that we talked about, where the lessor is required to give notice. It appears that it didn't satisfy that. So there could be an argument here. Were the alterations made with the required consent? Was it only alterations that were being removed? There could be a lot of arguments made, but in general, lessor is required to give that notice in that 60-day period, 30 to 90 days before expiration. Justin asks, are freezers, coolers considered trade fixtures? We didn't go into the definition too much of trade fixtures in this webinar. That was my last webinar, which you can view on YouTube. I think these are, without going too deep into the topic of that last webinar, I think these are trade fixtures. It's machinery and equipment that can be removed without causing material damage to the premises. It sounds like trade fixtures to me. I guess there are scenarios where the installation is so involved and it's done in a way where removing them, can't really be done without causing substantial damage. And in that situation, maybe they wouldn't be. Ben asks, if a property was delivered to a tenant, not move-in ready, so if a premises was delivered to a tenant and it wasn't move-in ready, how is it handled if there is a dispute between lessor and lessee in regard to what was pre-existing damage versus damage caused by lessee if there's no proof photos of condition of the premises upon delivery? Very good question. That is a bit of a repair and maintenance question, which we addressed in the last webinar to an extent. And, 7.1a, and let me see if I can bring this up and share the screen.
Hey, Usman,
Yes,
can you hear me?
I can.
Yeah, what I'm more regarding is when they vacate, like not like during the term of the lease. Let's say once they vacate,
Yep.
then there's often a dispute of, oh, this is beyond ordinary wear and tear, and then the tenant would say, no, this is how the premise was delivered to me when I first got it. That's my question.
Yep. So if it depends what the aspect is that lessor is claiming is not up to par. Paint, for example, if the premises, let's say carpet and paint, let's say it wasn't newly painted. The question is, and let's say when lessee is surrendering possession, it's just in horrible shape from, when it received possession, it wasn't newly painted, but there were just, scuffs and, it wasn't so bad. But when lessee was surrendering possession, it just looked really bad, the paint. It was really worn down. That's ordinary wear and tear. And so in that scenario, the lessor could say, this is not in a good condition, that it's so beaten down, the paint. You have to newly paint it. And what lessee might say is what you're alluding to, I think, that, well, it wasn't given to me newly painted. And that, I don't think in that scenario would be relevant. I think the lessor's position would probably prevail, that even though it wasn't given newly painted, it's in such bad condition, the paint, that in order for you to surrender it in a good condition, you have to newly paint it. So there are situations where, yes, the lessee would be required to place the condition of the premises in a condition better than it received it. Does that address your question, Ben?
Well, more so, I think the disputes happen is because people just start pointing fingers at each other because there's no proof, like there's no photos of how the condition was when it was first delivered versus when it was surrendered. So I think that's my question is,
Yeah.
how is that possibly addressed?
Yeah, I mean, it's better. It's better to have, documentation, but the language is a little vague in the AIR CRE lease, but that's somewhat intentional. Trying to, there are custom leases that have, surrender requirements, and it states in 2 or 3 pages everything that needs to be done by lessee when it's surrendering the premises. And the AIR CRE lease is just leaving it general. The basic obligation that we went over, that lessee has to put it in a good condition, order, and state of repair. It is vague, but there are scenarios that even though the lessor can require in some situations, like the paint example, that it is actually surrendered in a condition that is better than it was received. So, photos might be helpful it might give kind of practical arguments for both parties, but technically it's not required to have that documentation. Lessee still has to surrender it in good order, condition, and state of repair. Hopefully that's helpful. We can talk about it more, Ben. Feel free to call me if you have any more questions about that. Douglas asks, if the personal property is greater than 500 is left behind, no need to store it and then auction off. I think what Doug is referring to is a statutory, under California law, there is a statutory scheme for auctioning off property, personal property that is left by the lessee. There's a requirement to give notice, and after some period of time, lessors go through an auction process. What the AIR CRE lease is saying is that is not required. Lessor can dispose of it. Whether that is, whether there can be some technical arguments that lessee can make that the statutes would apply in this situation or that situation, for that type of advice, you want to talk to a lawyer before you take any action on something like that. Mike asks, is holdover prorated for the days held over, or is it month to month? Great question, Mike. And I think the reason Mike is raising that is because it does come up. And with custom leases, attorney drafted custom leases, we see specificity on that issue. Specificity as to, clarification that even if lessee holds over for one day beyond, and let me go back to this, even if lessee holds over for even one day, that lessee has to pay the holdover rent for the entire period of time. And let me go back to paragraph 26, actually, of the AIR CRE lease. I'll share this. So 26, the holdover provision, Mike, to short circuit your question, I think that it is kind of a month-to-month situation. And let me show you why. So hopefully you can see this. So it says here, due during the last, so the holdover rent that lessee has to pay is the rent due during the last full month before the expiration or termination of this lease, but with it being 150% of the base rent. To me, I guess my impression, Mike, would be that since rent and base rent is paid on a monthly basis, that holdover rent would be paid on a monthly basis. It just seems to me, my first impression is that would be kind of off the cuff the way I would look at it. And, if a landlord wants to include a very, a landlord favorable provision that even one day, if you hold over one day, you have to pay a full month and make that clear, that type of provision could be added. Randall asks, on holdover, can the holdover amount percentage be increased and or have an escalation for each month lessee may not vacate the premises, i.e. 150 to 200%, et cetera? Great question, Randall. And we see that. We see that frequently, that for some period of time, it's 150%. For the first month or for the first 2 months. And if there's a holdover beyond that time, then the holdover increases to 200% or 250%. And yes, I'm not aware of any limitation on having that tiered structure. Seth asks, if lessee is officially holding over and lessor has written to lessee informing of holdover and no response from lessee, is it best to engage you or an attorney to start an unlawful detainer? Is it best not to let this linger at all? So I think, Seth, whether you want it to linger as a lessor, whether you're okay with it lingering, depends on whether there's another lessee, whether you've signed another lease and there is a requirement to deliver possession of the premises to that new lessee. And paragraph 3 of the AIR lease, I'm just going to go to that to show you the provisions relating to delay in possession. So there's a 60-day window. So if there's a holdover and you've signed a new lease, that new lease under the default provisions of the AIR CRE lease, it doesn't automatically terminate the new lease, even if you fail to deliver possession of the premises by the commencement date. Lessor still has 60 days under paragraph 3.3 before lessee has a termination right. So if you've signed a new lease and you're a lessor and you're afraid of losing that new tenant, then you may not want to allow any holdover. And, some of our clients, for example, when they have that strict timing requirement for a new lessee, we actually, and we believe that the existing lessee is going to hold over. We send what we would call a holdover letter even before the expiration date. And we say basically in that holdover letter, we have signed, lessor has signed a new lease, is required to deliver possession of the premises. Please make sure you are out by, in the example I gave, June 30, and surrender possession by that date. And then if they're not out by June 30, then lessor can actually, decide it's not going to accept rent, start an unlawful detainer process immediately. And even if lessor does have some time, 60 days to deliver possession to the new lessee, by starting that unlawful detainer process on July 1 or soon thereafter, you're putting pressure on the existing lessee to leave. And even if they told the lessor they're going to leave in 2 weeks, you're not losing time. So if the existing lessee doesn't leave in 2 weeks, you've already started that unlawful detainer process. You've started out down that, that process that you need to undertake in court to get possession back. And if the existing lessee is delayed in surrendering, you still have an opportunity potentially, if you're the lessor, hopefully if you're the lessor, to remove lessee within that 60-day period and deliver possession to the new lessee. And I think this is the last question from Charles. Is tenant subject to recapture of leasing incentives, free rent, etc., if they hold over? Good question, Charles. You're looking at kind of what enforcement mechanisms lessors have, and you're referring specifically to paragraph 13 of the lease entitled, it's, I believe, 13.3, entitled inducement provisions. It might be 13.4. Let's see. 13.3, I shouldn't have doubted myself. Inducement recapture. And these provisions, Charles, apply in the event of a breach. If there is a breach by lessee, then free rent and other inducement provisions are due and payable. And is it a breach by the lessee if it fails to surrender on time? For that answer, you have to go to paragraph 13.1. Under the AIR, there's a difference between a default and a breach. And that probably gets into maybe a little bit of a analysis that's beyond the scope of this webinar, but there are remedies, and potentially that might be one of the remedies. And last question by Matt: a tenant had an above ground diesel tank but refuses to remove it. The lessee requires removal of personal property but says nothing. The lease requires removal of personal property but says nothing about fuel tanks. Generally speaking, what recourse does the landlord have, and what steps should be taken? I think a fuel tank that's above ground, my first impression, Matt, is that's personal property. It hasn't been installed. And so I think it has to be removed. Was that your question? And I think the lease also addresses removal of tanks. I think all tanks need to be removed. Let's see if I can find that provision. 7.4. Yep, it's right here. So for time purposes, I didn't address that in the 6 points. But under 7.4C, Matt, great question. Lessee shall remove all lessee-owned alterations and or utility installations, furnishing, and equipment, as well as the removal of any storage tank installed by or for lessee. So if it's a storage tank that's been installed, they have to remove it. If it's an above ground tank, I think that's personal property and it needs to be removed. Gotten to the limit of the 40 minutes. Thank you so much for your time and attention. I will turn off the recording and stay on for a few minutes if you have any additional questions. Thank you.